Good morning. We're here to talk about criminal law, and I don't want to impose any penalties for talking or being late for class, but so we're going to talk about crime, punishment, and the Roberts Court. Compared to some of the other topics we're going to talk about later today, I think criminal law is sort of interesting in it's not quite as ideological. The ideological divide is not as clear there as in other areas. You know, back in the 60s and 70s, crime really was the issue that divided the court. In the 80s and 90s under Rehnquist, there was still very much of a liberal-conservative neat split. I think in the late 90s, Justice Scalia in a number of areas on the confrontation clause and juries and search cases would sometimes take the position with the liberal side, and just as often Justice Breyer would join the conservatives. And 2 years in with Neil Gorsuch, he's a very conservative guy on a lot of issues, but not necessarily on criminal law. There's a fair number of cases where he's been on the liberal side. So I think it makes criminal law sort of a little less predictable and I think a little more interesting. We've got 4 issues we're going to talk about. The insanity defense and whether it's a constitutional requirement. The old question about whether a unanimous jury verdict is a constitutional requirement. A case about juvenile killers and whether they can be sentenced or must be sentenced to life in prison without parole. And then a case about when a political scandal can be charged as a federal crime. And we have an excellent panel to talk about these issues. Toby Heytens is the Solicitor General for the state of Virginia. Jeff Fisher, I think you all know, as a Stanford law professor, and I would say the most effective, most successful advocate for criminal defendants in the Supreme Court for about the last 15 years. And Stephanos Bibas, who was a longtime Penn law professor and since 2017 a judge on the Third Circuit Court of Appeals, and we're delighted to have him here at the William and Mary Conference. Why don't we begin with insanity? Stephanos, tell us about the case of Collin versus Kansas.
So, I'm the insane one? All right, thank you, David, and you've touched on a few themes. We'll come back to what connects the cases generally afterwards, but Collin versus Kansas is going to be argued at the very beginning of the term, beginning of October. The question presented is whether the 8th and 14th Amendments permit a state to abolish the insanity defense. You know, some issues about whether the 8th Amendment is fully preserved here, but let's just assume that the court can get to both of them. At common law, there have been a bunch of different tests for insanity. Anyone who's taught criminal law knows. There's this classic McNaughton test from 1843 that focuses on whether the defendant knew the nature and quality of his act or knew right from wrong. There was a volitional component of whether someone could control an irresistible impulse. There was briefly this, is it the product of a mental disease or defect test? There are lots of variations and flavors floating around. And they've developed many of them over the last century and a half. So how much of this is constitutional? The court had a series of cases. It had, Powell versus Alabama. It had, another one from Nevada, and it had Clark versus Arizona. And in each of them, it said, no, the irresistible impulse is not constitutionally required. This particular formulation isn't required. In Clark, it said, well, McNaughton, this 1843 case, I guess, from England, the whole of it is not required. You don't have to understand what you're doing as long as you can, in that case, the law in Arizona preserved the defense if you don't know right from wrong. Now, the question here is whether a state can get rid of even that and just say, you can use insanity to show that you lack mens rea, the guilty mind, the mental element of a crime. But is that constitutionally required or not? So Kansas and 3 other states don't have any insanity defense beyond mens rea. Alaska has an unusual one that has an insanity defense, but it does not allow you to argue that you knew right from wrong. So this is going to affect potentially the law in 5 states. And the Solicitor General of the U.S., interestingly, has come in on the side of the state saying we don't currently have a defense that narrow, but the federal government has an interest in potentially the flexibility to do so in the future. So it wasn't immediately clear what the federal interest was, but that's how they've articulated it. The petitioner here, Craig Collar, had a troubled marriage, was estranged from his wife over allegations of infidelity, and then after at the end of one Thanksgiving celebration at her mother's house, he broke in, he shot his wife, her mother, his two daughters, let his son go. And it was a brutal killing. There is some evidence that he committed the homicides in a dissociative state. The parties argue somewhat about what was in the record. Collar argues, the striking thing about these briefs that I think tells us a lot about where this court is and how different it was from 30 years ago, these briefs are fundamentally historical. Right? The frame of both of them is, here's how the law has developed, sometimes from the dawn of time. I mean, petitioner's brief starts at Genesis 2 and 3. And Adam and Eve's in the Garden of Eden about the knowledge of good and evil. That's how historical the briefing is. So petitioner is in Genesis, Talmud, Plato, Jesus, Justinian's Code, Islamic law, and then especially getting down to the nitty-gritty in English common law. From the evidence is that by the 14th century, according to Collar, insanity in the sense of not being able to know right from wrong was a complete defense to criminal charges. At the founding, Collar argues the common law did not allow for punishing the insane. And that, by the way, that is not contested here. There's a settled doctrine in the Supreme Court that you can't execute the insane. This is an issue about whether you can convict the insane without allowing this defense at the time, based on the mental state at the time of the crime, not at the time of the punishment. At the founding, Collar argues the common law didn't allow for punishing the insane, and that was connected to this idea that it would have been cruel and unusual to do so. As McNaughton was decided in 1843, he argues that by then, the ratification of the 14th Amendment, 3 decades after that, what codified it, so there's no doubt that the right and wrong notion of insanity as a defense to criminal culpability was absolute. So this also gets into what incorporation means, and does it have to have been ensconced at the time of the 18th century in the Bill of Rights or in the mid-19th century. So Collar argues the right to raise an insanity defense is protected under an originalist understanding of the 8th and 14th Amendments. Now, Kansas comes back with a historical brief of its own. It argues it does not, in fact, abolish the insanity defense, since it still lets evidence of insanity negate mens rea. It claims that it just has one of multiple permissible approaches to insanity. It says its approach has a common law provenance. So when it goes back through the history here, it says these historical sources, especially the common law 14th century on, they're about whether someone intended a crime. And so these references to good and evil are really references to whether someone had the mens rea for the crime or not. And it says it's right and wrong, that the right and wrong version from McNaughton is an invention of the 19th century. Remember, McNaughton's 1843. We can question what to do about that given incorporation in the 14th Amendment. So the parties hotly contest which version of the insanity defense has originalist bona fides. They also argue about whether a more modern approach to the 8th Amendment, assuming that an issue is preserved, requires a right and wrong insanity offense. Collar says punishing those who can't tell right from wrong doesn't serve retribution, deterrence, incapacitation, or rehabilitation, the four traditional justifications of punishment. Kansas disagrees, as does the U.S. Solicitor General. Kansas also claims that its mens rea approach might be more humane. It does less to stigmatize the mentally ill. It argues there's no reason that defendants who commit crimes due to mental defects that blind their sense of right and wrong should be any different from terrorists who commit crimes because their religious and political agendas tell them that they think the acts of violence are right or wrong or justified. More fundamentally, the Kansas resists the notion that the 8th Amendment can be used to dictate not just what modes of punishment are acceptable, but whom states can punish. It says legislatures can best determine who's blameworthy. Collar says the Supreme Court's decision in Robinson in 1962 says the 8th Amendment restricts whom the states can decide to punish. So the courts have to grapple with The court has to grapple with the historical evidence. The parties are disputing what was true in 1791, what was true in 1868, and Collar has to explain why this version of the insanity defense is codified among others. If I can just frame this a little in terms of the broader criminal law, I think that one of the real challenges here, as in many cases, like Apprendi, is what do we do with a criminal justice system that looks different from a criminal justice system that looked historically? In Apprendi, part of the problem was there was no sentencing phase at the time of the founding, and juries were doing some sentencing. Analogously here, at the time of the founding, blameworthiness and right and wrong were jury determinations. And by the way, everyone got a jury, unlike today, where most cases are plea bargained. And so we had these mens rea terms, but mens rea at common law, it's hard to get around. It's certainly hard to squeeze it down into little terms. Back at common law, a lot of the terms involved the idea of wickedness or wrongfulness, but was that understood in quite the way we mean moral wrongfulness? And yet most states today have moved mens rea towards this very clinical model penal code approach that's much more about could you know what was going to happen down the road if you did this, in a very cognitive way, not necessarily an effective or emotional way. And so we have a changed legal landscape, we have a changed concept of mens rea in courts, and what's the court going to do with originalist evidence, conflicting originalist evidence, and superimposing that on a system that both has different ways of attributing blame and different concepts into which we're trying to shoehorn it?
May I ask a question about how, I was puzzled reading the briefs about how Kansas, suppose a guy goes down to Kansas City street today, carries a gun, shoots 3 people, somebody says, you've killed 3 people on the sidewalk, and the guy says, yeah, I know, they were Martians. They were Martians and they needed to be killed. He deliberately killed the people, but let's say we're really convinced the guy thought they were Martians. What does Kansas do with that person?
Well, it depends. If he thinks the Martians are not humans, I mean, the classic is, even under McNaughton, if you think you're squeezing a lemon and not squeezing your wife's neck, you're not aware that you are killing a human being. Now, if he thinks that the person, it's in fact a human being, but this person was sent by the Martians or taken over by the Martians to invade, then you realize you're killing a human being, and so the mens rea defense wouldn't operate. But it depends on whether you're aware it's a human being. So if yes, fine, but there are other classic insanity conundra that we teach in first-year criminal law. Well, what if you hear voices that you think God is telling you to kill, right? There's this deific command doctrine in a lot of states. And if you know that you are killing a person, usually that's not enough, even though there are a lot of mental illnesses where hearing voices is a symptom in DSM-3 or DSM-4. And it's not clear that Kansas doctrine would allow that. But Kansas does make a point in its brief, which is the most we're saying is we want to hold this person liable. Our law actually gives a lot of flexibility at sentencing, right? Now, it's a little ironic here because Collar himself got the death sentence, but he did have the opportunity, they stress, to introduce a bunch of evidence and didn't, and the state draws an inference that he couldn't, even though there was plenty of ability to address it at the sentencing phase. So the question is, should this go to the ascription of guilt and blame in the first place, or just the degree of blame and punishment?
Jeff, did you want to say anything?
Oh, well, my answer, having grown up in Kansas City, my first answer would be Kansas wouldn't have jurisdiction because that crime would have occurred in Missouri.
Isn't part of the city in Kansas?
There is a Kansas City, Kansas, but not the Kansas, anyway. Sorry. But I think more seriously, I mean, one thing that picks up on your initial comments about the court as it views criminal law right now is there was a dissent from denial of cert about 5 years ago on this issue from Idaho, one of the other states, where Justices Ginsburg, Breyer, and Sotomayor said they would have taken the case, and Justice Kagan seemingly departed from her allies. And so one thing people took from that was maybe Justice Kagan didn't think the votes were there to do what the people who wanted to grant the case wanted to do. And it just brings us back to your point about Justice Gorsuch being
She was waiting for the arrival of Neil Gorsuch.
Maybe. I mean, it's just an interesting thing to watch and how they'll approach the historical arguments in this case.
Okay. So should we move on to Ramos versus Louisiana and juries?
Sure, I'd be happy to. But before I do, I just want to say thanks again for including me in the conference. It's something that's on my calendar every year as just a wonderful weekend, and so thanks for having me be part of this. So I'll give the spiel on Ramos versus Louisiana. I guess the first thing I should say is I'm representing Mr. Ramos, and he pronounces his name Ramos. And so, lest you think that I can't pronounce my client's own name, that's how he pronounces his name. This case is, as you said, about whether there's a Sixth Amendment right that applies to the states to a unanimous jury verdict in criminal cases. And I sometimes, this issue's been around for a while, as you said, and I've sometimes thought this is kind of like a trivia question. What do Louisiana and Oregon have in common? And the answer for many years has been they're the only two states that allow criminal convictions by non-unanimous verdicts. Interestingly, each through their own story. Louisiana's provision dates back to 1898 as part of its constitutional convention that helped usher in the Jim Crow era and adopted the grandfather clause, among other infamous provisions that were designed, to quote the sponsor of the convention, to assure the supremacy of the white race in Louisiana. Oregon's provision dates to 1934, and the evidence there shows that it was sort of a result of a fit of anti-Semitism. There were a couple of verdicts that were 11-1 where Jewish defendants were acquitted, and there was a great deal of public outcry that led to a popular initiative in the state. And so those are the only two states that have ever done this, and so those are their two individual histories. In 1972, the court actually looked at this issue in a case called Apodaca versus Oregon, and upheld, or you would say, upheld the state's rights to have these laws, but in a very splintered set of opinions. The court divided 4-1-4, with 4 justices saying that the way they would approach the question would just be a pure Sixth Amendment question of whether the right to the jury trial, as it is understood and meaningful today in contemporary society, requires today being 1972, requires a unanimous verdict, and 4 justices would have said, no, it doesn't. 4 other justices would have said the history of the Sixth Amendment, which I'll say more about in a moment, but the history of the jury trial right has always demanded unanimity, and they would therefore follow that history and apply it to the states and the incorporation doctrine. Justice Powell broke the tie, cast a vote in the middle. He said, I agree with the dissenters that the Sixth Amendment requires a unanimous verdict, but I would not apply that particular component of the Sixth Amendment to the states. And so that has sat there over the years, and in the past decade or so, the court has had two incorporation cases, one McDonald versus City of Chicago involving the Second Amendment, and then last term, Timms versus Indiana, dealing with the excessive fines clause of the Eighth Amendment. And the court has dropped 2 sort of uncomfortable footnotes in those cases, saying, the only deviation from our practice now, which is well settled, that any constitutional right that we recognize has to apply the same way to the states as the federal government, is Apodaca. And so shortly after the Timms opinion came out with a footnote like that, the court finally granted cert to reconsider Apodaca. So to pick up on a panel last night talking about stare decisis, this is one of those cases where the question presented is, should we overrule a past case? So let me tell you a little bit about what the arguments are, and then maybe my fellow panelists want to say a word as well. So Mr. Ramos, just to put the facts on the table quickly, was convicted of second-degree murder in Louisiana by a 10-2 jury verdict. And so the question, is, as I said, is whether that violated the Constitution. We are the petitioner. In our opening brief in the case, we basically start, as the court started in Apodaca, by recognizing there's really 2 pieces to this case. The first is what the Sixth Amendment requires, and the second is whether the 14th Amendment requires the Sixth Amendment to apply equally to the states. And so we start in the Sixth Amendment from a standpoint of precedent. We remind the court that 5 justices in Apodaca said that the Sixth Amendment requires unanimous verdict, and we count up 14 other Supreme Court opinions, both before and after Apodaca, where the court has said, sometimes in passing and sometimes more substantively, that the Sixth Amendment requires a unanimous verdict. And we say, that precedent and those prior statements are correct because if you look at the common law, which is how the court has told us, particularly in recent years, we should construe the right to jury trial as codifying the common law. You can go back to 1367. Now, I recognize in light of what you just heard about Genesis that seems like, I guess, like a lousy historical argument at this point. But we thought 600 years of common law was worth a little bit. So nobody disputes that the common law did require unanimous verdict. And so we say that's what the framers would have intended to codify in the Sixth Amendment. As for incorporation, we simply say Justice Powell's theory of partial incorporation was actually illegitimate when he announced it and has been fully renounced by the court since. And so stare decisis really has very little to say in this case because in terms of the 14th Amendment because of the splintered nature of the opinion and the fact that his vote is now just an utter outlier without any support in the court's case law. The state comes back in its brief and actually makes one interesting strategic move. I kind of think of it as going double or nothing. The state has not made a 14th Amendment argument in support of Justice Powell's partial incorporation theory. They've put all their chips on the Sixth Amendment side. So the state is now arguing just as a pure question of Sixth Amendment law that the Sixth Amendment does not require a unanimous verdict and that the four justices in Apodaca that took that view were correct. The state doesn't dispute, as I said, that the common law history required unanimous verdict, but the state does dispute that the framers intended to codify that common law aspect of the right. And I think the strongest evidence the state points to in that respect is an early draft of the Sixth Amendment, which was more detailed and said that the right to jury trial should be preserved, including the right to unanimous verdict and other details. And in the editing process, those extra language was taken out of the draft. And so that is principally what the state points to as evidence that the framers must not have intended to codify that aspect of the right because they didn't include it. We come back and say, well, there are a lot of state constitutions at the time that didn't include it, and everybody understood it still included that common law aspect. But there's a debate there about the history. So I think what's interesting then is it leaves us in a curious place in terms of stare decisis, where the court took the case, as I said, I think you could view it as one where we as the petitioner had to overcome stare decisis, or at least explain ourselves on the terms of stare decisis. But now, as the case has been briefed, the state is not even defending the pivotal vote and opinion in Apodaca, and the state is the one telling the court to disavow what 5 justices said in Apodaca and what the court has said 14 times in other opinions. So as the court has this much larger conversation going on about stare decisis, it'll be particularly interesting, I think, to see how they approach this case in that respect.
Let me ask one small question. I would say this is one, Jeff, where the odds are in your favor. I'd say 48-2. And it sure looks like they wouldn't have taken this case unless, what happens, assume you win, what happens to all the people who in the past have been tried and convicted in those states? Do they get a new trial, or would it be only for future jury?
Well, there's a set of questions, and I'm glad you asked that because it's one other important thing about the state's briefing that's interesting is even though the state does not defend Justice Powell's 14th Amendment holding in Apodaca, the state does say we have a reliance interest in those past convictions that the court ought not upset. And the state of Oregon filed a brief basically saying the same thing. So we have a set, for people who know retroactivity law, and we'll get to it more in a moment, we have basically some different categories of defendants. We have the easy category are the defendants on direct review. Those defendants, at least if they've preserved the issue, would certainly get the benefit of a decision from the court. But that's as far as we can say with any degree of certainty because this issue has been around so long and because so many defendants in these states really thought the court's never going to take up Apodaca again, you have a bunch of people who didn't even preserve an objection to non-unanimous verdicts or even cases where you're not even sure what the verdict was because the jury wasn't required to there was not a poll that was requested. So you have problems of record and preservation in some cases, and then you have problems of retroactivity potentially, where arguments are going to be made, first of all, about whether a decision like this would be a watershed rule that would be retroactive to defendants whose convictions have become final. The court has never found a new rule of criminal procedure to be a watershed rule, but there would be arguments in that respect, I think, perhaps for this. And then you also have arguments about whether the structural, whether this would be structural error as opposed to subject to harmless error. So I think it's fair to say there would be litigation if we win, but it's really difficult to say what the court or even the state courts would do with it.
And you don't think the court will give us any guidance on that point today? In other words, the decision won't say much one way or the other about what to do about past cases?
Typically, the court's practice is to just decide the constitutional question and let questions about retroactivity and post-conviction relief follow, as they do in Toby's case.
Well, that sounds like a good segue to move on to Toby's case.
Okay. So I'm realizing this is a sign of advancing age that I'm going to have to give a little background for at least the students in the room. And the background is that 2000 to 2001 was an absolutely bonkers time to be living in our nation's capital. Because we started in September of 2011 with the terrorist attacks that, among other things, it's 2001, that involved the Pentagon and the World Trade Center in New York. A week later, there was a bunch of anthrax mailed to various people in Washington, D.C. And then just when people thought things were calming down, 1 year later, in September and October of 2002, there was a string of seemingly random shootings throughout the national capital area. Where you had situations where people were like pumping gas or at a Home Depot being shot by an unknown individual with a high-powered rifle. It eventually, after a sort of significant investigation, was revealed that there were two shooters. One was a 41-year-old man named John Muhammad, and the other was a then 17-year-old man named Lee Malvo. So Muhammad drops out of this story pretty quickly. He was convicted in pretty short order, sentenced to death, and was actually one of the last people executed in Virginia without, I guess, a lot of legal controversy. So this case involves the 17-year-old offender, Lee Malvo. He was actually, the prosecution sought the death penalty against him because under then existing Eighth Amendment law, you could still get the death penalty as a juvenile offender, but the jury did not sentence him to death. Instead, he was sentenced to life without parole. He then pled guilty to a number of other crimes for which he was also sentenced to life without parole, and that was in 2004. But meanwhile, the Supreme Court is sort of still moving along while this is all happening. So Malvo is sentenced in 2004, and then in 2005, the U.S. Supreme Court begins a series of cases involving the Eighth Amendment restrictions on penalties for juvenile offenders. So in 2005, the Supreme Court holds that the death penalty for juvenile offenders violates the Eighth Amendment, so even if Malvo had gotten the death penalty, that would have been vacated because of this decision called Roper in 2005. Then in 2010, in a case called Graham, the Supreme Court says that you cannot sentence a juvenile offender to life without parole if that offender did not commit a homicide offense. That doesn't directly help Malvo, though, because he committed a large number of homicide offenses. But then in 2012, the court decides the first of the two cases that really takes center stage in this case, called Miller versus Alabama. And Miller versus Alabama, at minimum, well, you're going to see one of the debates in this case is what Miller versus Alabama said. But everybody agrees that at minimum, Miller versus Alabama says is that you cannot have a mandatory life without parole sentence for a juvenile offender. Yes, and in the interest of similar to Jeff's point, I represent the petitioner in this case, so factor that into your assessment of how I describe this case. But I think everybody agrees that at minimum, Miller says you can't sentence a juvenile offender mandatorily to life without parole. So having Miller decided in 2012, Malvo then files a petition for habeas corpus, federal habeas corpus, in 2013, seeking relief under Miller versus Alabama, the then recent decision in Miller versus Alabama. And per something Jeff was just talking about, he originally loses in the district court. The district court says, your conviction is long since final, and there's no indication that Miller versus Alabama is retroactive, so I'm denying habeas relief on the grounds that you're not eligible for relief under Miller versus Alabama. Malvo then goes up to the Fourth Circuit. The case gets delayed for a while, and while the case is before the Fourth Circuit, the Supreme Court decides the second case that's important in this case, and that's a case called Montgomery versus Louisiana, where the question presented is Miller versus Alabama retroactive to cases that were pending on collateral review? And by a 6-3 vote, the Supreme Court says that it is. So now, Again, the district court having ruled against Malvo on the theory that Miller was not retroactive, the Fourth Circuit sends it back to the district court to say, well, that's not going to work anymore because the Supreme Court has now said Miller is retroactive. And so that's when the sort of dispute that's now before the court sort of starts to take shape, where the dispute in a nutshell between, I'd say, the state and Malvo is, what is the holding of Miller, what is the holding of Montgomery, and how do the holdings of Miller and Montgomery fit together? So the state's argument in a nutshell is Miller's holding is expressly limited to mandatory life without parole sentences. The Supreme Court of Virginia has held that Virginia's sentencing scheme is not, in fact, mandatory. Therefore, he's not entitled to relief under the Miller rule, which was made retroactive in Montgomery. Now, Malvo's argument is a little different. He sort of argues two different things at the district court. First, he says, no, in fact, Virginia's scheme is, in fact, mandatory. So that is sort of taking issue with the state's argument on the terms of the state's argument. But he has a second argument, and the second argument is that in the course of holding that Miller was retroactive, Montgomery was required to consider and expound on the nature of the Miller rule. And given what the court said in Montgomery, it is now clear that the Miller rule reaches beyond mandatory sentences as well. So regardless of whether his sentence is mandatory or not, he got a life without parole sentence, and he didn't get what Montgomery holds that he's entitled to. So the way the district court resolves this is the same way the Fourth Circuit ends up resolving it, saying, oh gosh, the question of whether Virginia's scheme is mandatory or not is really hard, and probably as a federal judge, I feel deeply uncomfortable wading into the particulars of how Virginia's sentencing scheme works, so I am not going to decide that because that looks tricky. So I will assume for the sake of argument that Virginia's scheme is not mandatory. And then the district court agrees with Malvo that regardless of whether it's mandatory, the rule as explained in Montgomery applies to Malvo's case. Goes up to the Fourth Circuit. The Fourth Circuit says exactly the same thing. We are not going to wade into whether Virginia's scheme is or is not mandatory, but we're going to hold that as clarified in Montgomery, Malvo is entitled to relief. So the state, my client, seeks cert, and then the Supreme Court, and we wait, and we wait, and we wait, and we wait. In fact, by my count, the Supreme Court relisted this case 8 times before finally deciding whether to grant or deny. Fun fact, among friends and, in the privacy of this room, which I know will never be recorded, I was absolutely convinced they were denying cert. And I was absolutely convinced that they were waiting, that all we were waiting for was a dissent from denial, and the only interesting question is whether it was by Justice Thomas, Justice Alito, or Justice Gorsuch. And I was expecting a lengthy recounting of all of the crimes and how it's outrageous that the court has denied cert in this case. That was what I was utterly convinced what was happening right up until the moment that they granted cert. And so now the case is basically before the court, and we're basically having the same arguments. I think the only sort of real developments in the briefs is the briefs really are not engaging in the question of whether Virginia's scheme is mandatory or not. I think both sides have probably concluded that the U.S. Supreme Court has very little interest in deciding a question, A, that was not decided by the courts below, and B, seems like a tricky, difficult question of state law. And so the issue really, it really depends, right? So from the state's perspective, the question presented is, what is the holding of Miller versus Alabama? And from Malvo's perspective, he responds partly on that, because there is some language he relies on in Miller that he says supports the rule that he has. But it's also relying on what the court said about Miller in Montgomery. Now, the elephant in the room in this entire case, right, is the retirement of Justice Kennedy and the replacement of Justice Kennedy by Justice Kavanaugh, because Justice Kennedy wrote Montgomery versus Louisiana, the second of the 2 decisions. The first one is written by Justice Kagan. The second one is written by Justice Kennedy. And I think at minimum, one can say the following, and I think this would be an uncontroversial statement if Malvo's lawyer was here as well. Those 2 opinions are very different opinions, and the way they think about the issue, the way they discuss the issue, the way the breadth or the narrowness of their language, they are very, very different in terms of how those 2 opinions are written. I think that should be a relatively uncontroversial statement. And we can talk about why that is, but in many ways the question, and I think one of the things the parties are really struggling with over, because it's something that people talked about last night, the position of the Chief Justice as the sort of new sort of ideological center of the court. I think the strategy of Mr. Malvo is to say that the state is essentially asking you to overrule Montgomery, and you shouldn't do that, Mr. Chief Justice, because you want to be careful about the number of times you're overruling cases. And for the state's part, our position is this is just a straightforward application of Miller versus Alabama. And there's no one's overruling anything. Don't worry, don't panic, it's fine. And I really think it is overwhelmingly likely that the Chief Justice is by far the most important vote in this case. It's entirely likely that he may be the only vote that's important or seriously in play in this case. It's going to be argued the last day of the October sitting, October 16th.
So the bottom line is what's at stake here is whether Malvo will ever have a parole hearing at some time in his life? Is that, if you lose, he will at some point have a parole hearing?
He will at some point have a parole hearing on his Virginia homicide charges. One of the things that's lurking in the background is, at least by the facts that are recounted, he committed or attempted to commit 12 homicides in the DC area in about a 2-month period. So one of the things that makes the case a little interesting, and there's some articles about this even by some of his own lawyers, it seems extraordinarily unlikely that this individual is ever getting out of jail under any circumstances, because even if he were to win this case and even if he were to get parole on this offense, he also has life without parole sentences in Maryland, and he also probably has 7 or 8 homicides for which he was never prosecuted that he could now be prosecuted. But yes,
Yeah.
the question is whether he gets a
So
parole
it's
hearing.
not exactly home free.
No.
If he, well, so let's move on to the fourth case. The issue is, we have portrayed it as whether a political scandal can be prosecuted as a federal crime. This is the case of Bridget Kelly versus the United States. It's about the Bridgegate situation in New Jersey. This case seems like a setup for New Jersey jokes, but I'm not going to stoop to that sort of thing. In fact, some of the briefs make, I think, a really interesting big picture point, is that we're in a very polarized political climate when political rallies say, lock her up. And, you know, if I watch MSNBC in the evening, surely they will have a segment talking about various people who are in the Trump orbit who are under investigation and seem to be criminals and perhaps should be prosecuted. And then if I switch to Fox, they will have a segment on a series of people who are investigating the Trump people, and they seem like criminals and they should be prosecuted. And from what I take from it is that we should be very careful about the use of the criminal law and branding people as criminals in a very polarized time. So you probably know the basic facts of this case. Governor Christie was running for re-election in 2013. His campaign staff wanted to get various people to endorse him around New Jersey. They tried some nice things, like in Fort Lee. They spent $300,000 on free shuttle buses. That didn't work. And so the campaign did what used to be, the phrase was, they decided to go negative. And they changed the 12-lane bridges. There had been 3 lanes that were for traffic coming up from New Jersey onto the bridge. They announced they were going to do a traffic study, and they closed off 2 of those lanes, so there was only 1 lane, and it predictably backed up traffic in Fort Lee. This went on for a week. It was a big ruckus. Some various people, including David Wildstein, who seemed to have been the mastermind of this project, and a fellow named Bill Baroni, who worked for the Port Authority, and Bridget Kelly were fired. They lost their jobs. Wildstein agreed to cooperate, and about a year later, Bridget Kelly and Baroni were charged, indicted for fraud, wire fraud, obtaining government property, tried, convicted, and the Third Circuit, not on a panel with Judge Bibas, but upheld the convictions. And do you know what the crime, how it was portrayed? Is that, you know, fraud is essentially using a lie or deceit to obtain money or property. In this case, it was something to do with the bridge and the Port Authority. In other words, Bridget Kelly didn't get any money in her pocket. The theory of the case was that they used deception. And there's a line in the brief that I couldn't, I was sort of amused by. It says, Wildstein testified that they sat around in the office, the co-conspirators, and, quote, found it humorous that the Port Authority would have to pay a second toll collector to sit and wait in case the first toll collector had to go to the bathroom. Then it says, payroll records established that 11 overtime toll workers were paid a total of $3,696.09. Now, the reason that's important is that turns out that's the money. That this deceptive scheme required the misuse and misspending of $3,609 for overtime paid to these state toll collectors. And I thought, my God, I read about this every day. In other words, some government official has done something that seems deceptive for a hidden political reason. You remember there was a case just a few months ago about a commerce secretary who said, we're going to spend millions to collect, a citizenship question on the census. And we're going to do it to, further the Voting Rights Act. Well, everybody, wait a minute, that's not true. His real reason is something else. Would anybody think that could be charged as a federal crime, a fraud crime? And about 2 weeks ago, I read that the vice president was going to meetings in Dublin, Ireland, on the east coast of Ireland, and he was spending the night, he and the Secret Service contingent, on the west coast of Ireland in a hotel owned by Donald Trump. Now, scrub the president out of this, and Governor Christie was not charged in this case. But suppose we learn that somebody in the White House staff, let's say Bridget Smith, called and said, why don't we have the Secret Service and everybody fly to Western Ireland and put up the people, and let's put out the cover story, we're doing it for security reasons, safety and security, even though they knew that's a false claim. So here's what, in asking the court to uphold this, here's the government statement. It says, the petitioner, her co-conspirators engaged in deception in order to carry out a scheme that deprived the Port Authority, think Secret Service, the Port Authority / Secret Service of its money or property and served no legitimate Port Authority / Secret Service function. So I'm just raising the point that if this is a federal crime, that a government official used some money or properties and did it for a secret political reason, a deceptive political reason, is that a federal crime? Now, the briefs in this case are not, the merits briefs are not in yet. It was granted on the last day of the term in June, but I think it's a really potentially very interesting case on what is a fraud and what is a federal crime. And as I say, a lot of the discussion in the case is the concern is that it's very easy to look at the other side's people, other side's officials and say, they look like criminals, we should go after them. But anyway, I'll be interested to see. And we have, I was going to say 3 people who can talk about this case, but we have one member of the Third Circuit who probably should not weigh in on this because the case may come back. But do you guys have any thoughts on what do you think of this case? Because I thought it raised an interesting question about fraud prosecutions.
I'll say a quick word. I think in terms of looking at the court's trend or precedent, the most relevant touch point is the McDonnell case from a few years ago involving the governor of Virginia for engaging in various forms of graft, I think you might call it, where the court, I believe unanimously, in an opinion by Chief Justice Roberts, held that the federal fraud statutes could not be stretched to cover that, what the court itself described, I think, as unsavory political activity.
Yeah, he only took $175,000 in gifts and things.
So that was a unanimous court, and here we go again. So I think if you're looking at the Vegas line on this case, you'd think that the court took this maybe out of a similar concern of overstretching the criminal law. And I think that's the other thing I would just mention and use this case as a platform to circle back to one of your earlier themes, which is the 3 cases that we talked about until this were constitutional or quasi-constitutional. But the the Supreme Court's criminal statutory decisions are perhaps among the most interesting decisions the court is issuing these days because it brings this confluence of the libertarian streak among some of the Republican appointees, some other together with some of the Democratic appointees, and you get into these debates about textualism and all this modes of statutory interpretation. So I think seeing how the court approaches this case in that respect will be very interesting as well.
Jeff, do you know, when is the last time the government won one of these cases? When I think of like broadly the fraud, is X fraud under federal law? It has been a while, I think, since the government has won any case. Like, if the question presented is X fraud under the federal fraud statute, the answer seems to always be no.
For the last decade or two. Yeah, maybe that's a better trivia question than the one I had earlier.
Well, Judge, how about if we talked in general about criminal law? I'm interested in your view about
Sure.
the court in general in
As
this
I
area.
think I intimated, this is not your grandfather's court. You know, in the Warren Court era, a lot of the issues coming before the court were, you know, the way that you would Mirandize someone or how the exclusionary rule would operate. And those were ones that had some more predictable left-right divides. They were criticized by those on the right as technicalities. They were briefed in very pragmatic terms. The court has undergone a sea change on the kinds of cases it's taken, on the personnel, and on the ways it's approaching it. There's a lot of history in the briefs, even though policy and pragmatic arguments make it in there. I mean, several of these cases are heavily historical. You know, the personnel are looking at these cases through methodological lenses that don't line up neatly with political lenses. So I think Jeff and I might both have at least added a cautionary note to the left-right divide that the panelists last night were sketching out. In criminal cases, you know, you cannot pigeonhole some of these justices the way that you might on some others. And granted, it depends. You get to some death penalty cases, maybe the breakdown is a little different. And the other point I want to make is that a lot of these, both the substantive crimes and the procedural crimes, go to the fundamental things of what do we blame? What's blameworthy? What deserves punishment? And so, you know, in the insanity case, we're certainly seeing that. Ramos, a lot of it's about who determines blame and how certain are we are that someone deserves to be blamed. I mean, I think that's something certainly that runs through the juvenile cases too. What are the preconditions for making sure someone merits this sanction? And they're fundamental questions that lay dormant for a long time, and maybe, I don't know whether I date it to, you know, Apprendi and Blakely, but it's really the last couple decades that these have moved to the fore of the court's criminal docket.
I agree with that. I thought that one of the really interesting cases to read at the end of the term was one that Jeff worked at, U.S. versus Gundy, on the, because I took some time at the, you know, we're sort of rushing at the end of the term, and some of those cases, that case ended up deciding almost nothing, right? It was essentially decided nothing, but it was
Decided that Mr. Gundy lost.
yes.
That much was decided.
But I thought, I read Neil Gorsuch's, whatever you call it, the dissent, and Elena Kagan wrote this majority opinion, but they are arguing at one level about the non-delegation clause, but it's also a case fundamentally about, as Gorsuch said, there was something like 500,000 sex offenders who had committed crimes before 2008, and the question was whether this federal registration law applied to them, you know, and whether it was applied retroactively. And Congress didn't decide that. It basically said the Attorney General should decide this. And Gorsuch wrote this long opinion basically saying, this is not the way to run the railroad. Congress is supposed to decide this. We shouldn't allow one executive to, you know, it's somebody, I forget whether it was Gonzalez or somebody in the Bush administration basically decided this, and I think other administrations changed. And he had this very long opinion that I would have thought, if I scrubbed the names away, I thought, boy, this is a really liberal opinion. Here's a guy going out of his way to say we shouldn't treat sex offenders like this. This is not a fair procedure. And then Elena Kagan, taking the liberal view, had to say, oh, what's the big deal? You know, we can trust the government to do. And I thought it was, you know, if you looked at it as a criminal law case, it seemed like the conservatives were on the side of the criminal defendant, and the liberals were on the side of, oh, let's trust the government. You know, it's close, as somebody said last night, close enough for government work. We'll just allow the government to, you know, and most of the conservatives, people like me, write about them saying, oh, they believe in expansive government executive power. I mean, Gorsuch was arguing for the opposite, that we shouldn't allow the executive to make these kinds of decisions that are not reviewed. So for whatever it's worth, I think there are a lot of cases that you can actually read how they think about and decide, and they're not the typical view that the conservatives are against the criminal defendant and the liberals are arguing in favor of the.
Yeah, I mean, I'll just say a quick word. I think there's two ways to view Gundy. One is a criminal law case and one is not a criminal law
Correct.
case, right? So I think the way the case broke and got decided was the not a criminal law case way, where it was one about the non-delegation doctrine more broadly and the concerns that Justice Kagan, I think, and her colleagues in the plurality had.
I thought
in
Kagan,
that
she
respect.
almost did this in one other case. I thought she had to do it a lot of times. Say something at the beginning of the opinion says, now this case is not about this case.
Yeah, right.
In other words, we're arguing something really big here, but it's actually not what this particular case is
But
about.
insofar as it was a criminal case, and Justice Gorsuch to some degree viewed it as a criminal case, I think it ties very much into a line of cases that the court's been developing. I don't think there's one on the docket quite yet, but the void for vagueness line of cases
Yes.
on the criminal side, and ties probably most closely this term so far into the fraud case we were deciding,
Yes.
where you have Justice Gorsuch and some other justices expressing, I think it's a relatively new and quite significant development of expressing great concern at hazy, flabby, broadly written, inchoate federal criminal statutes.
Right.
And right now, they've focused just on the federal side, but there could be state statutes that could be brought to the table as well, because void for vagueness is a due process rule. And so I think that's where the view of non-delegation and Gundy comes together with this concern about void for vagueness doctrine. And I think that, at least the void for vagueness angle of it seems to be, have a lot of juice in it right now.
I agree. We've got about 5 minutes left. If anybody has any questions, we'd be glad to take any questions. If anybody has any thoughts on criminal cases or criminal law, we would. Yes, Jeff?
Going back to your discussion of the public corruption cases, the New Jersey case, the Collin case, are you able to explain why, or have any thoughts on why Marshall-Wythe's conviction was not reviewed by the Supreme Court, and what makes that one so solid, while the McDonald case and the New Jersey case are up for scrutiny?
That was a straight up fraud.
I don't know it well enough to say, Jess. I've paid attention to that for a while. Pardon me?
We were just discussing, and others may remember this better, but I seem to recall that was him just literally selling something, right? I mean, the person was paying him. And even in McDonald, I think the court made very clear, we're not saying that if, part of the problem in McDonald is there was no there was no allegation of a bribe directly to the governor. But even in McDonald, I think the court, when it's been narrowing these fraud statutes, it said, now of course, if you have like just literally bribery, someone just pays a government official to do X for them, we're not saying that can't be prosecuted. I think
That's certainly the way it was characterized, that he was selling his office, in effect, saying, you give me, now I do think there were campaign contributions, but if, you contribute to my campaign, or I'm not going to follow through on this particular hospital bill or something like that, it seemed like a much closer. Bridget Kelly and this guy, Baroni, I mean, as I say, they didn't get any money or property out of this scheme, and it was a political scheme. There seems to be even debate whether they knew, whether there was a traffic study or going on or not. But, so I think if you have a situation, I thought the Governor McDonald case was, I thought the court had to go out of its way to help him because, he took $175,000 in various gifts and loans. People said it was constituent service. I said this before, I think, this conference. I lived in Virginia all these years. I had no idea that, that if I was promoting a product like a book, that the governor would hold a big luncheon at the mansion to help me promote my product. Because that's what he was doing with this guy who was trying to market these supplements using tobacco. McDonald was getting all these gifts and use of his Ferrari and all that, and then using the governor's office to promote his product. And I said, what's the big deal? That he didn't take any official acts. He just set up meetings and tried to encourage other state officials to do something with this tobacco supplement. To me, that sounded more like an obvious case of corruption than something where it's like a mid-level person who's going to go to prison for, as I say, $3,000 paid unnecessarily for overtime for toll collectors. Seems a pretty small scale. Well, yes.
Mr. Heytens, you said something about how you have to be careful with the number of times
I think I was picking up off something that folks said on the panel last night in connection with the future direction of the Roberts Court. And there was a discussion that we're now in this relatively rare situation where you have the Chief Justice for the first time, I think someone said that since the 30s or 40s, that appears to be at the ideological center of the court. And we have a Chief Justice who is particularly an institutionalist and cares a lot about the institutional legitimacy of the court. And I think there is a perception that if you're a person who's particularly focused on that there is a cost every time you overrule a case in terms of the institutional legitimacy, public perception. And so I think I was sort of pivoting off that from the perspective, certainly from the perspective of people who are heavily invested in the court as an institutional player that has a reputation, or that you wish to have the court as a reputation, as the Chief Justice has said, is not a political body, that when the court sort of routinely overrules cases, particularly on predictable ideological lines, it strains this legitimacy and reputation in the way that at least many people care a lot about. I guess that's what I meant.
Well, thank you. We're about out of time. The next panel is at 10:10, so about 10 minutes from now. Thanks a lot.